May I come in, sir?
Please
Yes,
come.
please.
Good morning, sir.
Good morning.
Please have a seat.
Thank you, sir.
Please introduce yourself.
Sir, my name is Ayushi Arora. I'm 28 years old. I've done my schooling from Mount Carmel School, Chandigarh, and my graduation from UILS Punjab University in the year 2019. So thereafter, I started to prepare for the judicial services, and I also gave Haryana and Punjab Judiciary and also Haryana ADA last year.
So this is your first interview?
No, sir, this is my second interview.
When was your last interview?
Sorry, sir?
When was your last interview?
So in Haryana 2022.
Do you remember the question they asked?
Yes, sir.
What were those questions?
So first was the difference between decree and order.
Okay.
Second, I was asked about the difference between res sub judice and res judicata.
Right.
Then I was asked about the power of the magistrate under section 156 clause 3.
Yes.
Then I was asked about the essentials of a contract, and it was related to the damages of the breach
So what is the difference between a contingent contract and a wager?
and a
Wager.
wages, sir. So contingent contract under section 31 also defines, includes a contract which depends on a contingency which is collateral to the contract. So wager contract are the contracts which depends on the uncertainty of an event which may or may not happen, and it is given under section 30 of the Indian
But
Contract
that is
Act.
a similarity between both of these, wager contract also and the contingent contract also.
Yes,
we are
sir.
not sure whether the contingency would eventually happen or not for
Yes, sir.
100%.
Yes, sir.
So this is a similarity.
Right,
What
sir.
is the difference?
So I believe, so wager, in wager there has to be a profit or a loss for either of the party. However, in wager, I believe, sir, this condition can be waived off.
In contingent contract, are you
Yes, sir.
saying? So tell me this one thing, gambling is wagering or it is a contingent contract?
So it's wager.
Is it allowed? Wagering contracts are allowed
So
and
they are,
enforceable in India?
so they are void.
They are void?
Yes, sir.
So there are certain apps
Yes, sir.
which are in fashion these days.
Right, sir.
Like certain betting apps on cricket. You see it every day.
Yes, sir.
They are being promoted also.
Yes, sir.
So how are they operating if they are the wagering contracts?
So I believe there's a set limit. If a contract is within those permissible limits, it can be allowed.
What are the limits, ma'am?
So I'm not aware of it. I'll read about it.
Okay.
Okay, Ayushi, is there any
Yes,
difference between deemed decree and decree?
Yes, sir. So decree given under section 2.2 is a formal expression of an adjudication which determines a substantive right. However, sir, deemed decree is given specifically under section 2.2, which is the rejection of the plaint and application under section 144 of the CPC.
What is the meaning of deemed decree?
So deemed is a fiction created by the statute. The decrees which are not per se decrees, but the statute wanted it to be a decree and have the rights and the powers of a decree is put in the bracket of a deemed decree.
Okay. Is there a difference between case and offense?
Case and offense? Yes, sir. So offense, for example, sir, a case can contain non-cognizable and cognizable offences, but it will be deemed as a cognizable case. However, offence has to be a particular offence given under IPC or other statutes. Case can be the whole of the offences, which might have 2 or 3 offences in it.
When an offense converted into a case? At what stage?
So I believe after framing of charges.
Or its first information report after filing or after registering FIR? At what stage case is registered?
So after FIR, yes, sir.
Can we seek specific performance of an issue involving money contract?
So I believe we can.
Under which section of the specific relief act?
So section 10,
What is section 41?
section
41.
41, sir. It talks about injunctions, sir. It talks about that yes, sir. So the reliefs the additional reliefs can be asked with the injunction order itself, and it should not be asked later, as the bar of order 2 rule 2 will apply.
Can we seek enforcement of a money decree against a woman by sending her to a civil imprisonment?
No, sir.
Why?
Under section 132,
Why?
sir. So for the money decree, the statute explicitly provides that the woman shall not be arrested.
Why this difference between men and women? Now suppose if somebody challenges it under Article 14
Right, sir.
by saying that this is discriminatory against
Yes.
men, what are your thoughts on this point?
So I also believe the women and children are also given special status in Constitution itself. So I don't feel it's barring the equality right.
So what is the concept of reasonable restriction?
So it says that although we follow the principles of equality, but women and children and other special categories can be excluded from the right to equality and can be given special privileges for their upliftment and empowerment.
Please understand this. Why do you think women should be given this special privilege
Right, sir.
regarding the payment or non-payment of a money decree and should not be sent to a civil imprisonment, despite
Right, sir.
when there is a provision for attachment of their properties? Why they should be given special privilege in this particular circumstance?
Right, sir. So although it definitely shows that there is inequality between both the genders, so but I still believe, so women as by virtue of being a woman is always given a special status in the statute, and I believe the legislature in its wisdom must have thought of few reasons,
What are
and I
those
stand
reasons?
by
Exactly,
them.
this is what I'm asking.
Yes,
what are
sir.
those reasons, ma'am?
So I have to read upon
Do
it.
you think, now there is a statement which is at times being said by people, that we should be able to take dowry from the woman that we are marrying,
Yes, sir.
and if we are not given right to take dowry, then in that case we should not be able, and we should not be rather forced to give maintenance, because more or less 99% of the time it is the husband who is paying maintenance to the woman.
Yes, sir.
Whosoever is the wrong, that is a separate issue.
Yes, sir.
They say that we should not be allowed to not take dowry,
Yes, sir.
or either then we should not be forced to pay maintenance. What are your thoughts on this subject?
So I don't see a correlation between dowry and maintenance per se. Firstly, sir, dowry is an evil which has existed in the society, and dowry per se states that the woman is the property of the father or husband, in my opinion. However, some maintenance is a part of the Hindu marriages or even Muslim marriages, and it has been since times immemorial. During the Vedic period also, maintenance, the men used to be the bread earners, and they have to provide maintenance to the wife and the children. So the maintenance, even under the statutes or otherwise, is the part and parcel of marriage itself. It is not an evil which restricts or makes the women a property. However, sir, it also helps in preventing vagrancy and destitution of women and children.
Now tell me this one thing. There was another concept when woman was treated as a chattel.
Yes,
that
sir.
one particular section of the IPC was eventually struck down,
Yes,
because
sir.
Supreme Court felt that if we construe it as such as it is written,
Yes,
in that
sir.
case we would be furthering
Absolutely, sir.
the object that the woman has chattel. What was that section?
So 497 about adultery. So it was struck down in Joseph Shine versus Union of India 2017.
What was that provision which was struck down?
So adultery.
Adultery, those lines. I want
Yes,
to
sir.
ask.
So the women was not even made an abettor there, and the paramour of the woman was made the offending party. The husband can implicate the paramour of the woman.
There was another line that was something on the aspect that if the consent of the husband is taken.
Yes, sir. So if the connivance or consent of the husband is taken for sexual intercourse, it shall not be adultery, which is very regressive.
Okay.
So now the adultery is no more offense.
Yes, sir.
Okay. So a woman wants to live with a person other than her husband in a living relationship, and she wants protection from the Honorable High Court. So can she?
No, sir.
Why?
Right?
So the High Court or the law in itself, law of land protects the institution of marriages.
But it's about the fundamental rights, it's about Article 21, na?
Yes, sir,
So
definitely.
ma'am, please understand what sir is asking. There is an interplay between Article 21
Yes, sir.
and the personal rights of men and women. Now answer.
So the protection should be and must be given if both the parties are not married. I don't see that a woman seeking protection can infringe the institution of marriage itself first and foremost.
Suppose she says, I don't want any maintenance from my husband, I don't want kids, I just want to live with this person in a living relationship, kindly grant me protection. Then
So she can definitely go for divorce first.
Husband is not ready to give divorce.
once she go for divorce, then she can perform marriage with the living
Absolutely,
partner.
sir.
I am asking about living relationship only. She says, I don't want anything, single penny, don't want any property from my earlier husband, don't want kids, I just want to live with this person, I want protection.
And
Now-
her husband is not ready to give divorce.
Ma'am, please try to understand the analogy. Life
Yes, sir.
and personal rights. This is how you are supposed to be concerned as a legal person,
Right, sir.
as a person who knows the law. Which rights should prevail?
So I believe personal rights.
Personal rights.
Yes,
So
sir.
basically, just to prevent institution of marriage, you would not grant protection to someone and eventually they will be killed.
So
Now let
yes, sir.
fatwa was issued against
Hmm.
Mr. Salman Rushdie. Against he wrote a book called Setting Was. You know about it?
Yes, sir.
Fatwa issued
Yes,
from
sir.
Iran.
Hanji.
Whether he should have been granted protection or not.
Definitely should have.
Why? It was an issue between two Muslims. Muslim one wrote a book. Muslim two issued a fatwa.
Yes, sir.
Personal rights involved.
Yes,
Where was
sir.
he granted protection?
So the fundamental rights.
Then Article 21 is covered under which
Yes,
part?
sir. So he should be protected. Personal rights, sir.
Article 21 is under
Which
part
part?
of the Constitution?
So part 3 of the
What does
Constitution.
part 3 provides for?
Fundamental rights.
So whether fundamental rights will prevail over personal rights,
Yes, sir.
then then now do you want to change your answer?
So I do understand your concept, sir, but in my head, I believe, sir.
So morality, now tell me this one thing. If I do not give my seat to an old lady who is standing in the train and I have a seat, can the old lady prosecute me?
No, sir.
Why?
So because this is
No
not an
right.
offense. Yes.
It is only I was otherwise morally obligated to give her a seat.
Absolutely.
Morally, I am not supposed, and legally I am not supposed to leave my husband.
Yes, sir.
Understood?
Yes, sir.
But suppose I am leaving it. He can seek a decree of divorce against me.
Yes, sir.
But why I should not be protected? Because if I say that there is a threat to my life, why I should not be protected?
So she can definitely seek protection regarding the threat to her life, but
This is
not
what we were asking.
not to live in with another person and to
I want
maybe
to live in another
ignore the
person.
husband.
This is the whole story. This is the problem. She wants to live with a person in a living relationship. That's against society.
So I stand
She has
corrected.
threat.
Yes,
Someone
sir.
kill her or her living partner. That's why she seeks
And
protection.
nobody seeks
Yes,
protection
sir.
saying that allow me
Yes.
to live with my
Living
partner.
partner.
Yes, sir.
Protection is
So I
against a
stand
perceived
corrected.
threat.
Yes, sir.
Obviously, when we are saying that she is
There is a
wanting
threat
protection,
perception.
Yes,
That's
sir.
why she
there is a
come to the
perceived
court.
threat.
Yes, sir.
There is a perceived threat in it.
Yes,
it is
sir.
in here. You understood it now?
Yes, sir.
All right.
So tell me, where the term judicial service defined?
Sorry, sir.
Where the term judicial service defined?
So I'm not aware of it, but I can make
What
a
is
guess.
judicial service?
So the judicial services are the services wherein the recruitment of judicial officers is done.
By whom?
So by the High Court and the HPSC together.
Okay.
And what is the service that you would be performing if you are appointed as a judicial officer?
So I will have to adjudicate matters both as a civil judge and a judicial magistrate first class.
What are the principles that you have to keep in mind? Obviously, that would be taught in
Yes,
the
sir.
training if you are selected, but right now, there must be
Yes,
certain
sir.
principles you feel. Yes.
So I feel the first and foremost principle is to be impartial and fair.
Impartial.
Second, sir, I'm a judge. must adhere to the legal principles and must not go beyond it.
Judge is supposed to know the law.
Yes, sir.
Therefore, it is said that in pleadings, a person is not supposed to write the law. Can you explain a bit upon this statement?
So, under Order 6, the golden rules of pleadings are given under Rule 2. It says that the parties must plead facts and material facts and not law or the evidences. That is, so the pleadings must contain factum probandum and not factum probans, which is the evidentiary facts, or he should not plead the law, that is the presumption of laws or the facts which are laws, and that the judicial officer must know.
Suppose there is a person who has filed a plaint or a written statement by saying that this is the judgment I wish to rely upon. Now suppose in answer to para number 2, the person is writing a written statement, he says that in reply to this particular para, I want to place my reliance upon XY judgment, and he cites the judgment, quotes a para, right in the WS. What should be done?
So
it appears to be against Order 2, Rule 2, sorry.
Yes, sir.
Then what is to be done?
So
should we accept it, or it should be sent back saying file it in accordance with Order 6 Rule 2?
So it should be in accordance with Order 6 Rule 2.
Where is it written that it has to be, otherwise this would take place? Everything has an effect.
Absolutely.
If a person does not follow Order 6 Rule 2 mandate, first question is it mandatory to follow?
No, sir, it should be liberally construed.
The liberally construed should not be given back.
Yes, sir. Yes, sir.
Okay.
Ayushi, as a civil judge, can you pass a degree without issuing summons in any situation?
So the principle of audi alteram partem should be given, and opportunity of hearing to the next opposite party must be given first.
So
there is no provision can a suit be disposed of on a first hearing?
Yes, sir, under Order 15.
So is it mandatory to issue a summons in a case?
So I believe natural justice has
Exceptions
to be
are there or not?
Could be, sir. I have to read upon it.
Okay, have you recently go through the latest judgment of the Honorable Supreme Court regarding reservation sub-classification within a category? State of Punjab versus Devendra Singh.
No, I have to read upon that.
Okay.
Sir.
Whether issues are framed in a counterclaim suit.
Yes, sir.
I filed plaint,
Yes, sir.
you filed WS, in which
Yes,
you filed a
sir.
counterclaim.
Yes, sir.
Now suppose if issues are framed, decree is passed, how many appeals would arise from that?
How many? Sorry, sir.
How many appeals can be filed against?
So both the parties can file appeals to the part they are not agreed.
Can I file, how many decrees would be there, 1 or 2?
So both the issues would be decided.
Issue, okay, tell me this one.
Yes, sir.
Issues are framed in one single
Yes,
day.
sir. Yes, sir.
There is one set of issues framed.
Yes, sir.
Whether 2 decrees would ensue or only 1 decree would ensue from that case?
So one decree.
1 decree?
Yes, sir.
Sure?
Yes, sir.
Not 1 decree saying about A's case, another decree about B's case, no?
Although, sir, both the claims are the cause of action of both the different parties. But I believe...
So 2 different cause of actions.
Yes, sir. 2 different cause of action by plaintiff and defendant, respectively. So I would take a guess that 2 decrees can be made, sir, deciding both the matters.
So this is one exception you are saying, appears to be an exception, that in one case 2 decrees would ensue.
So as also mentioned by the Supreme Court, there can be
Which
2
case?
final decrees, Shankar versus Chandrakant.
What are 2 final decrees then?
So that...
So 2 appeals would lie eventually.
Yes, sir. I believe so. Appeal would lie against the part which the party is not agreeing to.
Obviously.
Yes, sir.
So basically 2, alright, 2 degrees you say,
I believe so.
and 1 judgment.
Yes, sir.
Or 2 judgments.
No, sir, 1 judgment.
Sure.
So decree shall also be 1, but both the claims shall be mentioned in.
So, but
there shall be 1 decree, but both the cause of action shall be mentioned in it. And the resultant decree must be there, the resultant part.
Obviously that
Yes,
will
sir.
be there in the decree.
So
Otherwise it will
1
not be
judgment,
decree.
1 decree.
So now you...
Yes, sir, I believe.
So tell me, can an interim stay be granted to plaintiff without hearing the defendant?
Yes, sir.
Under which provision of secrecy?
Order 39, Rule 3
For how much time?
30 days.
And after that,
So the plaintiff, the court shall ask the defendant to appear and plead before it.
I say court has discretion to extend that without hearing the defendant.
So under 148, I believe the court can extend up to 30 days again.
It is discretion.
Discretion.
What is the scope of interference in execution petition? If there is an execution filed seeking execution of a decree,
Yes, sir.
in that case, what is the scope till which an executing court can interfere and grant relief to the parties?
So the executing court, although have wide powers, but it
Wide
cannot
powers.
go behind the decree, sir.
Or beyond the decree?
It cannot go beyond and behind the decree, and so only as mentioned under section 42,
40?
if I am not wrong, sir. The executing court can discharge the decree,
Discharge the
satisfy
decree, satisfy
and
the
execute the decree, but cannot go behind the decree.
What do you mean by this going behind?
Go
and
behind the
beyond?
decree.
Going beyond the decree, sir. So
What is
as
the
it
meaning
is,
here?
so as it is, what is written by the court must implement
Now,
that.
let me give you an example. A and B, they are A, B and C.
Yes, sir.
A filed a case against B saying that there were certain things which you were supposed to perform, you chose not to perform, give me that much money. Okay?
Yes, sir.
Settled.
Yes, sir.
But there was a tripartite agreement between A, B and C.
Right, sir.
When A filed suit against B, B didn't take, but he didn't include C. C
Okay.
was not included.
Okay.
B didn't take any objection regarding him being what?
Implemented.
Implement as a necessary party or a mandatory party or whatever they
Right,
call
sir.
it. Decree was passed between A and B. Alright? B didn't satisfy the decree. A went to executing court. A said that allow me, direct him to give my money, otherwise send him to prison. Now he takes an objection. Then there was a tripartite agreement between A, B and C. C was, you bring that particular document of NOC from C, I will give
Right.
them.
Right, sir.
Then what should the executing court do?
Sir, this matter pertains to the power of the court granting the relief. I believe, sir, the court shall listen to the parties.
Which party, ma'am?
The parties to the suit, sir. The entire
Obviously,
party.
ma'am,
Yes,
that has
sir.
to be.
Yes,
you
sir.
please don't do this. Obviously, parties are to be heard.
Yes, sir.
A is saying C has nothing to do. He was not a party. Decree is passed between A and B. He is who? He is nobody. B says he is the most important person. There was a tripartite agreement. Decree is between A and B. So now the question stands is whether executing court can go beyond
No.
X, Y, Z of the decree.
Yes, sir.
And now can direct C to come in between and grant NOC.
No, sir. That is beyond the power of executing court. The C can have another suit. He can have his own cause of action. He cannot go to the executing court, sir. It shall be beyond the powers of executing court.
What is section 42?
So that the executing court shall have all the powers
All the powers
to discharge,
to discharge.
satisfy and execute the decree.
So, do you think in any manner this will be affected by that?
No,
Whether
sir.
it will not be in the scope of the executing court to do that?
No, sir. It will be beyond the power.
Ayushi, which subject do you like the most?
Sir, I like Evidence Act.
You are the 8th candidate who says the same thing.
Why?
So I believe it's very exhaustive, so candidates find it better.
The least number of sections are there, that is why everyone appears to be so fond of evidence.
I believe so.
So tell me, is there any section which provides you a right to produce evidences before the court?
Section 60,
Section 60?
real evidences.
Evidences.
Evidences, sir.
Is there any section under the Indian Evidence Act which allows you to produce the evidences before the court?
So Section 5,
What it says?
that the evidences can be given of two things, facts in issue and relevant facts, under
Okay.
Section 6 to 55.
Okay, is there any difference between relevancy and admissibility?
Yes, sir. So relevancy is a genus which is wider and admissibility is a small part of it. So relevancy is a legal relevancy which the Evidence Act
Okay,
provides.
the additional evidence defined anywhere in Evidence Act?
Sorry, sir?
Additional evidence is defined anywhere in Evidence Act?
No, sir, I don't believe so.
Sure.
I could be wrong, sir.
So where it is defined?
Additional evidence, sir? Sorry, sir, not aware.
No, at what stage admissibility of an evidence is to be seen?
So right at the moment where evidences are produced.
Now, understand it. Evidence as somebody brought an evidence, admissibility is challenged. The court, as per your opinion, should then and there decide it.
So under 136, court can ask the
Very
parties.
simple.
Sir is asking the
It is
stage.
very simple question.
Yes, sir.
You are a judge.
Yes, sir.
I am before you
Yes,
to
sir.
depose. He is my opposite counsel. I produce a document. He takes an objection regarding admissibility. Whether that objection
sir.
should be decided then and there.
It can be, sir.
It
Yes.
should be or it should not be.
It should be.
It should be.
Yes,
This
sir.
is your opinion. Now,
Yes, sir.
problem that I am saying would arise would be, you decided it against me. I went to the honorable different courts, High Court, Supreme Court, XYZ. That things, that particular thing would take at least 2 to 3 years to decide. That one aspect.
Yes, sir.
It is decided in my favor. Next day, another witness came. Admissibility, objection.
आप तो एडमिसिबिलिटी पे ही रह गए.
Problem that would arise is, after a point of time, the trial would take 20 years to complete.
Yes.
Then 1st April, 2nd April, as April. Don't you think that would frustrate the purpose of the suit?
Justice delayed, justice denied.
Yes, sir.
It will.
Yes, sir.
Now tell me, justice hurried is justice buried?
Buried. Yes, sir.
True.
Yes, sir.
Give me an example. Then fast track courts are antithesis to this principle. Justice hurried is justice buried.
Sir, I think both the principles have to be balanced. For example, sir, Order 37 summary suits. Although there's a provision that it has to be hurried if the defendant as
But
does
it
not
can be
have a right.
converted into a real suit.
Yes, sir. So that's why, sir, I believe that's why the court also takes a very wider discretion in it. If
No.
they have real evidence.
Fast track courts.
Yes, sir.
Do you know what are the examples of fast track court?
No, sir, not aware.
Do you know what is a fast track court?
Yes, sir.
What is it?
Where, sir, the pleadings are expeditious, sir. They
No,
don't take
pleadings
long.
is a concept of civil law.
CPC.
Yes, sir.
In civil cases, do you ever, did you ever even had a chance to come across a case which was tried as a fast track case?
No, sir.
Then don't use word pleading.
Yes, sir.
Then it is generally done in criminal cases.
Right, sir.
Then it is, you can say it as
Right.
a case,
Right,
not
sir.
the pleadings.
Right, sir.
And don't give example of CPC. then.
Right, sir.
POXO cases,
Right, sir.
do you know what is POXO?
Yes, sir.
POXO is what?
So, offences against women and
Any
children. Sexual
any
offences.
time frame fixed to decide the case?
There has to be, sir. I have to read upon
You have
it.
to read about
Right,
it.
sir.
Ayushi, why you want to become a judge?
So there are two reasons. Firstly, it was my father's wish, and after his demise, I also started noticing the impact judiciary have on society. So secondly, I was always taught that work has to give bigger purpose in life. I think after being a part of the services, I'll be able to contribute to something which is bigger than my own identity and to be able to help others as well.
Anybody a judge in your family?
No, sir.
Lawyer?
Advocate.
No, sir.
So Ayushi, last question: who is the current Chief Justice of Punjab and Haryana High Court?
Sir, it's Justice Sheel Nagu.
Okay. Any
The term rarest of the rarest case introduced in judgment
Sir, Bachchan Singh versus State of Punjab.
only.
Sir, it was introduced pertaining to death
Are you aware
penalty.
about Machi Singh case?
Yes, sir.
What was the facts of that case?
Sir, I am not aware of.
What was held in that case?
So, that the death penalty has to be given in the rarest of rare cases, and death penalty is not the rule. The life imprisonment should be
Do you
given.
know
and
the recent case of Kolkata Medical College?
Yes, sir.
It is the rarest of the rarest.
Yes, sir. I believe.
Can you tell me, last question from
Yes,
my
sir.
side, can you tell me a brief chronological history of the cases which has developed the jurisprudence of the Indian Constitution? When I say this, like starting from 1950s, like Gopalan and all that, then Minerva Mills, then Keshavanda Bharati, and then cases came. I might
Yes,
be missing
sir.
a few names.
Yes, sir.
Can you give me this chronology of cases, how the Indian Constitution has developed and emerged as a concept? मालूम है आपको?
Yes, sir.
Thank
I can recall. So first would be 1951, like you said, A.K. Gopalan. So second would be so I'm so sorry, I'm not able to recall.
Third, fourth, fifth.
So
Any in continuous?
yes, sir. Then probably on the third number it was Keshwananda, then Minerva Mills.
Minerva was before or after Keshav?
After, sir.
Sure.
I believe so, sir. I'm not able to recall the chronology, but
Then-
it was I could remember the page, but I'm not able to remember the cases.
Alright then. So Gopalan, Keshav, Minerva,
No, sir.
these three I said.
Yes, sir. There are many in between.
After ma'am.
सज्जन सिंह, इंदिरा साहने.
Yes, sir. Yes, sir.
Alright.
Thank you, sir.
आयुषी, जो मैंने नोटिस किया है, एक तो ना आप आई कांटेक्ट नहीं कर रहे हो, आप आंखें चुरा रहे हो बीच बीच में, है ना?
Right.
जब पैनल में से कोई मेंबर आपसे क्वेश्चन पूछ रहा है तो
जी।
इधर उधर देख रहे हो, फिर बीच में देख रहे हो, फिर इधर उधर देख रहे हो.
ठीक है.
और दूसरा ये कि जब अगर सर क्वेश्चन पूछ रहे हैं तो आप सिर्फ सर को ही आंसर कर रहे हो,
Right,
राइट?
sir.
रेस्ट ऑफ द मेंबर्स को आप इग्नोर कर रहे हो,
ठीक है.
है ना? तो इसको थोड़ा सा इम्प्रूव करना है. लीगल कंसेप्ट्स आपके अच्छे हैं, गुड टू गो, है ना? बाकी मेरी तरफ से ठीक है. सर एनी फीडबैक फ्रॉम
आयुषी जी, आपको ना डोमिनेट अच्छा है, आवाज़ हमें सुन रही है, अब बैठने का तरीका भी सही है, एवरीथिंग इज गुड. लॉ पे ना आंसर आपको वो देना है जिस पे आप स्टैंड कर पाओ, स्पेशली व्हेन इट इज अ सब्जेक्टिव क्वेश्चन. सब्जेक्टिव क्वेश्चंस आर ऑलवेज ओपन टू डिबेट्स.
Right, sir.
ऑब्वियसली जितना हम आपसे डिबेट करें उतना कोई शायद वहाँ ना करे, कुछ समय थोड़ा होगा.
जी.
But at times when you are taking a particular side in a subjective answer, then you should have a backing about it.
Okay, sir.
मतलब impulsive भी अगर आंसर दे रहे हो तो वो मुद्दा होना चाहिए ऐसा कि आपके बारे में ऐसा सोचा गया हो.
ठीक है.
कई बार जो जैसे ज्वलंत मुद्दे होते हैं आज के दरमियान जो
जी।
चल रहे हैं, लाइक दिस डॉक्टर्स केस, XYZ केस, UCC coming in उत्तराखंड and
yes,
Assam
sir.
government trying to bring some new law,
हाँ जी.
and few I'm forgetting somebody else was also
Work
trying
and
to
all. हाँ जी. हाँ जी.
So if you would want to take a stand upon it, every stand would be correct in the eyes of the person who take it, but you
Right.
at least have certain backing about it.
Okay, sir. ठीक
ऐसा
है.
ना हो कि तीसरे सवाल में ही कॉन्ट्राडिक्शन आपकी आयरॉनिकल हो जाए और
ठीक
ये
है.
ना लगे कि यार यू हैव नॉट थॉट ओवर इट.
ठीक है.
प्रॉब्लम इज यू वुड नोट द लॉ. दूसरा इंटरव्यू है आपका, कानून तो पता ही है. कानून तो ऐसी चीज है जो समय के साथ सीख जाता है. इट इज नॉट
Yes,
बहुत
sir.
मुश्किल चीज नहीं है.
Yes, sir.
But the development of their mindset to understand the framing of those questions and the issues is very much relevant.
Yes, sir.
जो philosophy है, जो principles हैं,
जी.
उनके बारे में थोड़ा सा सोच विचार थोड़ा कर लेना है.
ठीक है.
बाकी मुझे ये लगता है पढ़ाई कब है आपका इंटरव्यू?
19th.
आपके पास 14 दिन है, उन 14 दिनों में आपको पढ़ाई छोड़नी नहीं है.
Right,
At
sir.
times the problem arises is we tend to give it a casual
जी.
go कि यार
जी.
या तो आता है या नहीं आता है,
जी.
हो जाएगा देखा
जी.
जाएगा.
जो रेस्ट ऑफ द सब्जेक्ट्स
ने
हैं
पूछा जैसे
जी.
रिजर्वेशन के ऊपर,
जी.
वो नो द
हाँ जी,
रिसेंट
सर.
जजमेंट.
जी.
ओके,
जैसे ना take some good subscription of जो आता है वो टक 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 आता
ठीक
रहता
है.
है.
एक ये जो पीछे आपके हेयर आप ऐसे ही करके जाओगे,
नहीं सर.
ये बहुत डिस्ट्रैक्ट करते हैं पैनल को ना
हाँ,
पीछे.
नहीं, सर.
एक आपकी
Proper
नेक
हाँ।
ज़्यादा ही मूवमेंट करती है
ऐसे ऐसे
ठीक है.
आंसर करते हुए.
ठीक है.
ट्राई टू बी स्ट्रेट.
Sturdy,
ओके,
हाँ जी.
और एड्रेस टू द बेंच ऑलवेज. एक चीज़ जो मैंने नोटिस की आपके अंदर, आप जब कोई आंसर नहीं आ रहा है, आप टाइम ले रहे हो, ठीक है, जब अगर आप टाइम ले रहे हो ना, यू शुड प्लीज टू द बेंच फर्स्ट.
Okay, sir.
Shall I take a
Right,
minute?
ठीक
Okay.
है.
You request to the bench first कि आपने टाइम लेना है, then you will recall
ठीक
and you
है.
will answer. Okay.
ठीक है सर.
बाकी all good.
सर माय क्वेश्चन है सर, मुझे प्रैक्टिकल एस्पेक्ट्स में नहीं
द
पता.
प्रॉब्लम इज वो किसी को भी नहीं पता है.
ठीक
अगर
है.
उनको चाहिए होते प्रैक्टिकल तजुर्बे वाले लोग तो उसमें 5 या 4 साल प्रैक्टिस मैंडेटरी.
वो एक्सपीरियंस ऐड ऑन
जी.
कर देते
पर
हैं.
सर फिर वो बैक टू बैक जब प्रैक्टिकल पे चले जाते हैं फिर आई एम क्लीन बोल्ड
to be
है.
very honest, there are certain there are times when people have seen things in their internship.
जी.
और जैसे प्रैक्टिकल एस्पेक्ट ये था जो मैंने आपसे एक सवाल पूछा था कि किस स्टेज पे क्या होगा. इसमें ना सुप्रीम कोर्ट की जजमेंट्स हैं जो आपस में दो का व्यूज है. ठीक है. एक कहती है कि क्रिमिनल केसेस में कर लो,
ठीक
सिविल
है.
में मत करो.
आपको नहीं पता तो आप फोर्स मत करो आंसर करने के लिए ना,
ठीक है.
आप मना कर दीजिए.
आप बोल दो
ठीक
कि
है.
सर तुम एज पर माय ओपिनियन शुड बी टेकन एट दिस.
राइट. ठीक
अगर
है
वो ऐसे
सर.
पूछेंगे तो इस चीज़ में वो नंबर भी नहीं काटेंगे.
ठीक
अगर
है.
आपको मैं क्या होता है ये जो प्रैक्टिकल एस्पेक्ट आप ये तो आपको ट्रेनिंग में सिखाया जाएगा अगर आप सिलेक्ट होते हो तो, ठीक है। इसका मुद्दा सिर्फ इतना सा है कि हमने आपकी चेन ऑफ थॉट्स जो है उसको एक जगह ले गए, देन वी स्टॉप यू।
राइट सर।
वी माइट वांट टू आस्क यू द नेक्स्ट क्वेश्चन, बट देन जैसे ही आप फंसे हो ना, और अगला सवाल आएगा, देन वी वांट टू सी हाउ कॉन्फिडेंट आर यू अबाउट द नॉलेज दैट यू हैव गैदर्ड। उसका आंसर ना गड़बड़ा जाए इसके ना पता होने से।
ठीक है,
दिस इज द कोरिलेशन दैट
यस
इज
सर
सीन।
जी।
प्रैक्टिकल एस्पेक्ट आपको नहीं, अब क्लैट के बच्चे से अपन ये थोड़े पूछ लेंगे कि कानून में क्या लिखा है।
वो क्वेश्चन सिर्फ आपको ट्रैक से उतारने के लिए
ट्रैक से
होता
उतारने के लिए
है। आप ट्रैक से उतर के वो दोबारा ट्रैक पे आ गए, आप नीचे ही घूम रहे हो अभी, राइट?
That happens, sir. Thank you.
What was the last score?
I scored really bad, 28 out of 200.
लास्ट हरियाणा ना,
Yes,
सबको ये गलत ही नंबर
बहुत-
28?
Yes sir.
आउट ऑफ 200।
200 out.
एंड व्हाट अबाउट पंजाब?
पंजाब मेंस क्लियर नहीं होता।
Mains clear
हरियाणा एडीए में से स्कोर अच्छा था, बट मेरिट लिस्ट नहीं।
ओके। आयुषी, एक तो ये जजमेंट जो सब क्लासिफिकेशन की ये
Yes sir.
बेल इज रूल, जेल इज एक्सेप्शन, ये बहुत चल रहा है आजकल,
ठीक है।
है ना? सुप्रीम कोर्ट की काफी सारी
स्पेशली इन पीएमएलए केसेस के रेफरेंस
यस
में।
Yes.
ये पूछेंगे।
ठीक है, सर।
और दूसरा एक ऑल इंडिया जुडिशियल सर्विसेज पे अभी चीफ जस्टिस ऑफ इंडिया की लेटेस्ट जो स्टेटमेंट आई है उसको थोड़ा सा कंसीडर
ठीक है,
करें, है ना?
ठीक है सर।
रेस्ट यू आर गुड।
Best of luck.
बेस्ट ऑफ लक।
Thank
Wish you all the
Okay.
best.
Thank
Go with
you
a
very
positive
much.
mindset.
Thank you.